But AB 832 expires on March 31st, 2022. And upon that expiration, municipalities can create, modify, or extend their old moratoriums. So that's really what the Los Angeles moratorium is doing.
Hi, this is Kris German. Welcome back to the Apartment Dealer Show. Today we have with us Mr. Mike Brennan, eviction attorney extraordinaire. Now, if you've been a subscriber to our channel of any time, you've seen Mike before. And if you're asking yourself, well, why do you keep bringing back the same eviction attorney? It's simply because Mike is one of the best, and he serves the local landlords here in Los Angeles County, San Bernardino County, Riverside County, Orange County, Ventura County. He has offices in multiple locations. And Mike and I today will dive into what are the current laws that have come into the books for 2022, what are the proposed laws for 2022, and with the recent extension of the Los Angeles County Eviction Moratorium, what does that mean to you and I as owners of multifamily properties here locally? Be sure to subscribe to our channel, turn on the notifications so that you receive the interviews as we record them throughout this year. Keep in mind, over the course of 2022, we're going to be releasing that much more content, and we will be bringing you the information, the resources, and the network of professionals that are going to help you build your financial legacy in multifamily properties. With that, help me welcome Mr. Mike Brennan. So Mike, thank you for being with us here today.
You're very welcome.
And so, of course, starting back in 2020, there's been a barrage of new laws, regulations, and just here days ago, Los Angeles County extended their eviction moratorium. And with that comes a number of not new, but extended regulations. And so we're going to dive into that today, Mike, and you're going to help us sort through this. So let's start there, of course, with the extension of the eviction moratorium, and let's help give the landlords some guidance of what are the new rules in place?
Okay, so I'm going to give you as you said, Kris, a 40,000 foot overview on this. We're still unpacking it and developing strategies for it. So for right now, it's probably best to start off by saying the state has its own COVID eviction moratorium that everybody knows is AB 832. Mm-hmm. And that the state's moratorium allows service of notices for unpaid rent. It has a preemption clause in it that prevents municipalities from their own moratoriums unless it was already in effect back in August 19th of 2020. But AB 832 expires on March 31st, 2022. And upon that expiration, municipalities can create, modify, or extend their old moratoriums. So that's really what the Los Angeles moratorium is doing. It talks about a three-tiered phase out of eviction protections. Realistically, phase one is actually an increase in protections. It's a step backwards, really. Beginning February 1st, the LA County eviction moratorium is extended, and that's the old moratorium. So right now you can still serve notices, you can still file evictions for unpaid rent. None of that changes. But on April 1st, then all of that changes. Now all of a sudden we go back to the protections for non-payment of rent that we had, a long time ago under LA County. And you will not be able to evict tenants for non-payment of rent. The really egregious part about that is that the tenants will be able to self-certify that they were impacted by COVID. Mm-hmm. And that means really nothing. They can make it up. They don't have to prove anything. The one thing they will have to do is notify the landlord within 7 days of rent being due each month that they've been impacted by COVID and they can't pay the rent, but they don't have to provide any documentation. They don't have to prove they've been impacted, and the landlords won't be able to evict them based on that. So that's phase one starting April 1st. That has no limitations on it. Every tenant, regardless of how much money they make, will be protected through phase two. Now, phase two is where we start to see a backing off or an easing up on the restrictions. Phase 2 starts June 1st of 2022. And at that point, several things go into effect that actually start to help the landlord. First, we'll talk about non-payment of rent because that's the most common. At that point, only those households that make less than 80% of the adjusted mean income for that area are protected. So in other words, if you make 81% or more of adjusted mean income, as of June 1st, 2022, you can now be evicted for non-payment of rent. The problem, of course, is how do you prove that a household makes what percentage of the adjusted mean income? And that's very difficult, but we're developing a strategy to work that out right now. The other protections that are starting to dwindle are owner occupied. Right now, LA County will allow an owner occupancy eviction, but there's a whole list of limitations on it. You have to have purchased the house prior to a certain date. The tenant, if the tenant claims they were ever impacted by COVID, you can't do it right now. You've got to be in the same position as the tenant. In other words, if the tenant is disabled, the owner has to be disabled. There's a whole list of limitations. As of June 1st, a couple of those limitations are relaxed. So in other words, there will be no purchase date prerequisite. And even if the tenant has been impacted by COVID, the landlord will still be able to do an owner occupied eviction. So that's beginning June 1st. And then, as I said, the adjusted mean income kicks in so that you can evict people who are making 80% or 81% and greater of the adjusted mean income. Starting June 1st, you still cannot evict unauthorized occupants or unauthorized animals. You can't evict the tenant for unauthorized occupants or unauthorized animals, and you still won't be able to do nuisance evictions. Then we go into phase 3, which starts, let me just double check the date on that so I don't get it wrong. Phase 3 starts January 1st, 2023, and that goes through June 30th. And at that point, again, the same AMI protections will be in place. 81% or better, you can file evictions for non-payment of rent. But at that point, there's no restrictions on owner occupancy, and all of the other eviction protections will be removed. In other words, as it stands right now, you'll be able to evict for unauthorized occupants, you'll be able to evict for nuisances, you'll be able to evict for unauthorized pets, you'll be able to evict for failure of the tenant to allow access. And going back just a little bit, in phase 2, you will also be able to evict for failure to allow the landlord to come into the property. So they do phase it out.
So if we could stop there. So again, the recording of this video is February 2022. And because of these videos and because of YouTube and the work we've done together, I get, my office gets a number of calls asking us some of these legal questions. And of course, we always defer them to you, but I want to be able to at least understand some general answers here. So as of right now, for things like nuisance, tenants that are not allowed to live, or individuals living in the unit that are not lived in, that are living in the unit, you can evict for these things, or you cannot.
You cannot. You cannot evict for a nuisance. You cannot evict for an unauthorized occupant or an unauthorized animal. You cannot evict for the tenant failure, refusal to allow access to the owner. This is all under the county's moratorium. Currently, you cannot do any of that.
So can you only evict then for, or I shouldn't say only, but it sounds like one of the main reasons then you'd be able to evict for, and it's a short window, is for non-payment of rent. But then in April, that changes, because if they self-certify COVID, then that goes away.
You got it. You just nailed it. Right now, you can evict for really 2 things. You can evict for non-payment of rent, and you can evict for any other breach of the lease except unauthorized occupants, unauthorized animals, and refusal to allow access to a landlord. And you can right now do an owner occupancy, but there's a whole list of requirements you need to meet, including one that says if the tenant's ever been impacted by COVID, you can't evict them. And all that starts to phase out. It goes backwards on the non-payment of rent, because as of April 1st, like you said, now all of a sudden you cannot evict for non-payment of rent, but that in phase 2, that changes. Phase 2 starts in June of 2022, and you will be able to evict for non-payment of rent, provided that the household makes 81% or more of the adjusted mean income. And those protections start to diminish as time goes on.
And what about rental increases in LA County Incorporated? So my understanding is they've left it to the individual cities to basically determine if they want to put another layer. But if you're outside the unincorporated areas, you can raise rent.
That's correct. You got it perfect. Outside of unincorporated LA County, you can increase rents as long as there's no local moratorium in place prohibiting it.
And with the unincorporated component to this, it's interesting. I just found out yesterday that in Baldwin Park, there's a portion of the city that's unincorporated. Unbeknownst to me, and a client of mine owns an apartment building there. So unfortunately, she falls under those guidelines. But sometimes you might not even know that you're in the unincorporated area. So unincorporated differs, Mike, and you can better explain. But my understanding is not only have they extended their eviction moratorium to the end of this year, but they've also extended no rental increases for the remainder of this year.
That's correct.
So now we're going on 2.5 years where unincorporated LA has not allowed any rental increases. Anything a landlord can do in that respect, or it just is what it is?
The increases, there's nothing a landlord can do right now. I will tell you, Kris, we have a trade organization on which I sit on the board of directors. We have the approval, the board has already approved for us to go ahead and sue the county. We've hired a law firm. It's a law firm we've used in the past in these moratoriums. It's been very successful. And it is our intention to bring a lawsuit against the county because there's an aspect of this moratorium. It's the self-certification part that the United States Supreme Court has already ruled unconstitutional in a case out of New York that had the exact same self-certification allowance. The United States Supreme Court said, sorry, that denies the landlord due process. If a tenant is allowed to self-certify, the landlord should have the right to go in and challenge them and make them prove that in exchange for the waiver of rent, they have to show that they were impacted by COVID. So since the Supreme Court has already ruled that to be an unconstitutional component, LA County's extension, this new moratorium extension, is illegal on its face. So we're drafting it right now. We are going to be filing that lawsuit and seeking an injunction against this before it kicks in.
Well, good. I wish you good luck there. I mean, this has been a long, we're talking about over a 2-year fight now.
It'll be 3 years by the time this is all over.
Yeah, my goodness. Okay, so where we are so far is basically for some of the main reasons you typically would evict for, you can evict throughout most of this year. Now, when you said that unless it's a breach of the contract in some other shape or form, what would be some of those instances that you see would be a slam dunk, so to speak, in eviction court that a landlord, because if a landlord has a tenant who has tenants living there that are not supposed to be living there, and they have a tenant that is a nuisance, but you're saying, hey, they've taken those away. Obviously now they're going to be drilling through their rental agreement saying, hey, is there something else that this tenant maybe is doing that they hadn't thought about? Any other or what would be those issues that you would take a look at?
So for example, let's say they were assigned parking spaces. I'm just using one that pops into my head, and the tenant, and they're prohibited from parking in fire lanes, for example. And the tenant consistently allows people to come over and park in their own space, and they go and park in the fire lane. That's one example. That would be a breach of the contract. And that is a situation that you would be permitted to go to court on that. There's plenty of them. Probably the most egregious one I can think of right now would be a provision in the lease that says no modifications to the property without the landlord's prior written consent. And the tenant goes ahead and installs a Ring camera, a window unit, air conditioning, starts building onto the property. At that point, yeah, you'd be able to go to court and file that eviction.
And what's the process for that now? Whatever the issue may be, whether they're parking outside where they're designated, or they've made modifications to the unit. What's step one?
Step one is document it. Before you even say a word to the tenant, document the problems. Take pictures of it if you can, write it down, the date, time, witnesses, what happened, what was said by who. You want to document everything. Documentation is the key to winning lawsuits, or at least evictions. Once you've documented it thoroughly, and if it's, for example, if it's the parking issue, document it multiple times. Then I would tell you to serve a notice. And you might want to serve the notice with some form of an explanation that says, hey, pursuant to paragraph 9 of your lease, you're not permitted to, make modifications to the apartment. We've discovered that you installed a window unit, air conditioning unit on such and such date in the upstairs window. You're required to remove it within this number of days, et cetera. And I will tell you that you've got to figure out which jurisdiction controls your notices, because, for example, if you're under statewide just cause eviction, then you've got to give a notice that's a warning first. And then if they don't comply with the warning, then you do a 3-day quit. But if your property's not under the statewide, typically you would just do a 3-day cure covenant notice. And you don't have to serve the second 3-day quit. So the first step is document it. The second step is to serve the appropriate notice. And the third step is, if they haven't cured it, you go ahead and file the eviction. And I would tell you, document the fact that they haven't cured it as well, because you'll need to prove that in court.
Now, let's say, because I know you serve other counties as well as we do, San Bernardino County, for example, where do things stand with evictions and rental increases right now, assuming we're not talking about a city that may have its own extra layer? In general, where are we with evictions and rental increases in San Bernardino County?
San Bernardino County is a little slice of heaven. So is Riverside. There's no moratoriums. There's no limitations on rent. I will tell your viewers, one of the things that has popped up, and we were going to talk about this in the new laws, is there's Penal Code 396, which is an anti-price gouging law, which states, there's a specific subdivision in there that states, in a state of emergency for a period of 180 days after that state of emergency is declared, a landlord cannot raise their rent more than 10%. So if you go to my website and you go under the resources tab, you'll see rent increase resources. Click on that. And then you will see the anti-price gouging link. Click on that and you can look it up by county, and it will tell you if that county has any states of emergency in effect and when they expire, et cetera.